The nationwide lockdown announced on March 24th at short notice has caused immense distress to migrant workers around the country. Thousands of migrant workers are walking across India in a desperate attempt to reunite with their families in their native places. Questions are being raised about their welfare and the lack of legal protection for their rights. Those in the field of labor welfare have recalled a 1979 law to regulate the employment and working conditions of the interstate migrants. As part of the reforming labor law, a bill has been introduced in Parliament called the Occupational Safety, Health and Working Conditions Code of 2019. The proposed code seeks to merge 13 labor laws into a single piece of legislation. The Interstate Migrant Workmen Act of 1979 is one of them. But activists fear that specific safeguards given to migrant workers may be lost as a result of this consolidation. The Act seeks to regulate the employment of interstate migrants and their conditions of service. It is applicable to every establishment that employs 5 or more migrant workers, or if it had employed 5 or more such workers on any day in the preceding 12 months. The Act would apply regardless of whether the 5 or more workers were in addition to other employed in the establishment or by the contractors. It envisages a system of registration of such establishments. The principal employer is prohibited from employing interstate workers without a certificate of registration from the relevant authority. Every contractor who recruits workers from one state for deployment in another state should obtain a license to do so. The registration of establishments employing interstate workers creates a system of accountability and formalizes the utilization of their labor. It helps the government to keep track of the number of workers employed and provides a legal basis for regulating their conditions of service. As part of the licensing process, contractors are bound by certain conditions. Providing terms and conditions of the agreement on the basis of which they recruit workers. These terms include the remuneration, hours of work, fixation of wages, and other essential amenities. If the nature of the work is similar, then the wage rates, holidays, hours of work, and other conditions of service of a migrant worker shall be the same as other workers in the same establishment. In other cases, it would be as prescribed by the appropriate government. In no case shall the wages be lower than what is prescribed under the Minimum Wages Act. The attempt to consolidate these laws means that many separate laws concerning various kinds of workers and laborers will have to be repealed. The proposed law seeks to repeal 13 acts such as the Factories Act, Mines Act, Dock Workers Act, the Interstate Migrant Workmen Act, and other enactments relating to those working in different fields. Both the old Act and the proposed code envisage the payment of a displacement allowance and a journey allowance to interstate migrant workers.